Oyez, oyez, oyez. The Honorable Supreme Court of Arkansas is now in session. All persons having business before this honorable court, draw near, give attention, and ye shall be heard. May God save these United States, the state of Arkansas, and this honorable court.
Well, good morning. Welcome to today's session of court, this being the first session of the new year. And at this time, I'd ask the clerk to please read the submissions.
There are 10 appeals being submitted to the court for decision this morning, the first of which will be our oral argument, CR-20-581, Zachery Keesee versus the state of Arkansas from Faulkner Circuit. Criminal 21-85, Anthony Beard versus the state from Hot Springs Circuit. Criminal 21-347 is a state's appeal versus Daryl Lamont Scott from Pulaski Circuit. Civil 21-375, Anarian C. Jackson versus Dexter Payne as the Director of the Division of Correction. Civil Case 21-581, John Thurston in his official capacity as Secretary of the State and others versus the League of Women Voters and others, an appeal from Pulaski Circuit. We have Criminal 21-17, Sammy L. Thomas Jr., an appeal from Faulkner Circuit. The final four appeals are all appeals against the Director of the Department of Correction. Civil Case 19-124, Malik Muntakim is the appellant. His appeal is from Pulaski Circuit. Civil 19-261, Jesse Hill is an appeal from Lincoln Circuit. Civil 21-178, Melvin Jefferson appeals from Lincoln Circuit. And finally, Civil Case 21-220, Larry Rayford appeals from Lincoln Circuit. In addition to these 10 appeals, there are 17 various motions and petitions being submitted to the court this morning for decision. All of the court's decisions on motions that are handed down today, as well as these submissions, are available on the court's website.
Okay, thank you, Stacy. Let me mention that Justice Baker is unavailable for this morning's session, but she plans to watch the argument and to participate in the decision. Our case for oral argument today is Keesee versus State, CR-20-581. And the court recognizes the appellant. Mr. Kaiser.
Mr. Chief Justice, and may it please the court, I am Michael Kaiser, and I'm here today on behalf of Appellant Zachery Keesee. I would respectfully ask to reserve 5 minutes of my time for rebuttal. The state's evidence showed that on May 8th of 2018, two men, Andrew Morstein and Christopher Bynum, burst into Leonel Panduro's hotel room in Conway, Arkansas, where Morstein shot Panduro multiple times, ending with a kill shot to the head from less than 2 feet away. Both men fled from the scene in two separate vehicles. This was not some sort of drug deal gone awry, as the state alleges on appeal, but a targeted hit and assassination. There was no allegation that Zachery Keesee was directly involved in Panduro's death, only a series of actions that Keesee purportedly took following Panduro's death that at worst constitute hindering apprehension under this court's case law and Arkansas statutes. The state's attempt to cast this as anything other than a cold-blooded, purposeful murder is unavailing. The statutes make clear that luring someone to their death under the ruse of a fake drug deal is not felony murder, but is purposeful or premeditated. There was insufficient evidence of Keesee's guilt under either theory of capital murder presented to the jury, and the trial court erred in how it submitted the felony murder theory to the jury based on an incorrect definition of delivery, and an attempted delivery simply is not enough by the express terms of the capital murder statute. Further, allowing the state to amend the felony information just weeks before Keesee's trial in a manner that was inconsistent with his co-defendant Bynum's plea just weeks prior was a due process violation. And while we acknowledge that the Supreme Court of the United States has not yet found such a due process violation based on the use of inconsistent theories across different co-defendants in the same case. The Eighth Circuit has, as have other federal circuit courts of appeals. This second theory was merely a subterfuge for the state to introduce copious amounts of character evidence regarding Keesee's alleged drug trafficking, which formed the bulk of the state's case against Keesee at trial. One simply cannot be guilty of felony murder if the intent of the perpetrator upon entering the dwelling was to commit the murder, as here. I intend to focus on 3 points specifically today. Point one, the insufficiency of the evidence under either charge theory that my client was an accomplice to premeditated murder or an accomplice to felony delivery murder. Point two, the due process violation resulting from the state's use of inconsistent theories across co-defendants. And point 9B.
Counsel, let's start with the insufficiency of the capital felony murder. Although a substance found in the hotel room wasn't tested, don't think that there's enough circumstantial evidence to establish that it really was a shooting of a victim, part of an attempted drug deal.
Well, Justice, our position would be that that would be insufficient. An attempted delivery is insufficient under the express terms of 510-101A1 AX. So an attempt would be insufficient. I would also disagree. Merely finding a purported controlled substance in the room, there was no proof of any attempt of money being delivered or any other element of a delivery. The only proof was that there was motive of a premeditated murder where two people came from out of state into this state for the express purpose of killing Mr. Panduro.
Counsel, wasn't there evidence that there was a text from one of the individuals saying, "I am coming to bring you money," and that would be evidence of money involving a drug transaction?
Justice, I have to acknowledge that the evidence showed there was a text from Andrew Morstein to the decedent about bringing, quote, Frankie's money. Without more, there's nothing to say that that was in relation to a drug deal that was occurring at that time, as opposed to some prior debt. Simply put, the circumstantial evidence was insufficient to show that even an attempted delivery occurred in that hotel room or anything short of a premeditated and calculated assassination.
Counsel, if it was, we're looking at it in the light most favorable to the state, and watching the video, I apologize for my throat, counsel, but looking at it in the light most favorable to the state, which is our standard, if you're watching the video, both gentlemen were there when the victim opened the door initially and let Andrew in. So if it was solely premeditated and deliberate, as you're saying, nothing else, and the jury had nothing else to consider, they could have walked in at that second, walked in and killed him if that was the only thing the jury could find, and killed him at that point. But instead, what the video shows is that he went to the door, went in, spent, a significant portion of time in the room alone, and left, and then went to his vehicle, went back, and at that point, the two went in and killed the victim. So wouldn't that be sufficient to show there enough to get to the jury that there could be another reason other than they went to the scene only to kill him?
Justice, respectfully, we disagree. Without any additional evidence, there's insufficient circumstantial evidence to show that even an attempted delivery, which again, we do not believe is sufficient to meet the felony murder statute, occurred. Moving to the other theory presented by the state in this case, for which my client was convicted, premeditated and deliberated murder. First, I'd just like to start with accomplice liability. As the court knows, it's a mixed question of law and fact, and it's our position that the court needs to make the legal finding before even proceeding to the sufficiency of the evidence. And in this case, because this was a capital murder case, my client we believe there's insufficient evidence to show premeditated and deliberated murder because he did not have the requisite mental state as an accomplice. As this court found in Lawshay v. State in 2009, that's 2009 ARC 600, the accomplice must act with the culpability required for the commission of the offense. Causing the death of a person, as in a murder or a manslaughter, is a particular result. And so here, the state had to prove that my client had that same culpable intent in order to show sufficient evidence on this theory.
Counsel, can we return? I mean, I think we're maybe still on the felony murder and no evidence, again, viewed in light most favorable to the state. Is your argument that the felony murder and the delivery could only happen in that moment at the hotel room, or can the time be expanded? Because there is evidence that, you know, there was a package sent to his sister. The defendant told the sister, don't give it to the victim the night before. And she went ahead and gave it to the victim. That there's an argument that was part of the delivery and attempted delivery, and then them to get that back. Can the time frame be expanded?
Justice, I believe the answer to that question is, in theory, yes, it can. But in this case, no, it can't. And that's because of the language in the course and furtherance of. And so once a purported delivery has completed, I don't know how the state's theory could be that anything was done in furtherance of that completed delivery.
Unless it's to pay for the package or to get the package's return.
But in this case, there was no proof tying any such payment to the package, or even proof that the methamphetamine found at a different hotel room was what was contained in that package.
And counsel, does it matter? I mean, does it matter if that's what was in the hotel room? Or is it enough that they went there to attempt to get delivery? If you attempt to buy drugs, does it matter if there's actually drugs there?
Under the express reading of the statute, it does, and an attempt is insufficient. The legislature would not have used the term actual delivery if they intended for a constructive or an attempted delivery to suffice as the underlying felony for felony murder. That term is not superfluous. One cannot attempt to commit an attempted delivery.
So it would behoove a criminal to not be able to effectuate, to fumble in terms of actually getting the drugs or something out of a hotel room. So if the delivery goes awry, that plays to a criminal's favor. That doesn't seem like that would be something the legislature would intend those words. If they fail to get the drugs behind the piece of furniture, or there's some failure in making that happen, you're saying that works in favor of criminal defendant?
Justice, I apologize. You cut in and out during that question. If you could repeat.
I was just saying, I think it is of concern that which would be a criminal defendant this would play into his or her hand if the drug delivery exchange failed, if it went awry, if it didn't actually into like Moore's hands, a debacle in trying to hand off the drugs. That doesn't happen. So that it's an attempt and not an actual delivery. That's what I'm hearing from you. Is that correct?
I guess it does inure to the benefit of some criminal defendants in some cases, Justice, but that is the way the statute is written.
Counsel,
yes.
Counsel, and you're telling me that's how the statute is written, but if I'm looking at Arkansas Code Annotated 565-1016, it says delivery means the actual constructive or attempted transfer. So you're telling me attempted is not there, but it is in 1016, the definition of delivery.
Yes, Your Honor. And in the statute for capital murder, under this theory of felony murder, 510-101A1AX, it puts the term actual before the word delivery. That term,
Grammatically, it's actual, comma, constructive, comma, or attempt. And that grammatically means, when you interpret it, attempted does mean delivery. I mean, it's not, it's it can be actual transfer, constructive transfer, or attempted transfer. That's what the statute reads.
I
Are you
can't,
disagreeing with that?
no, ma'am, I can't disagree with the definition of delivery in the controlled substance statute, but I continue to focus on the use of the term actual in the capital murder statute. The legislature would not have included the term if they meant to include an attempted or constructive delivery. Otherwise, the term would be superfluous in violation of this court's rules of statutory interpretation. As in this case, if someone uses the ruse of a drug deal to lure someone to their death, that is a purposeful homicide. Under this court's rule in Sellers, an assault committed in furtherance of the murder, it is not something committed in furtherance of the underlying felony.
Well, counsel, can you give me your best argument on why, in the light most favorable to the jury, taking all the evidence in, why the jury could not find the defendant guilty of capital murder?
Under both theories or a specific?
No, just straight up, yeah. Premeditated murder.
Okay. Under that theory, Your Honor, there was insufficient evidence that my client had the intent or that he did any action to cause the death of Mr. Panduro. And as this court adopted but-for causation in Brown v. State last year, if we remove my client from the mix, Mr. Panduro's death still would have occurred in the exact same manner. Moving to point 2, the due process violation by permitting the state to proceed with inconsistent.
Counsel, sorry, I'm not going to let you off that easy on that, but the jury had in front of him that the weekend before the murder, that occurred, I guess, Tuesday morning, that the victim was threatening to cut his fingers off, that he had been attempted to kidnap, that he was hiding out in a safe house, and that he was going to get his boys to take care of the situation for him. You're saying that those two would have came up from Texas and killed the victim, without the defendant being involved?
Yes, that is one of the reasonable conclusions based on the circumstantial evidence presented at this trial.
What fact do you have to suggest they would have came to Arkansas if Mr. Keesee would not have been involved? And you can answer that without it taking your time.
Thank you, Your Honor. I would just point to their own statements, to their own respective girlfriends and spouses, saying that they were coming to this state specifically to kill someone for theft of drugs. They made it clear their basis for coming to this state. And while we challenge the admission of those statements elsewhere in this appeal, we believe it makes it very clear that this was a premeditated murder from the start, and they came from out of state. Going back to the court's mention of the getting his boys to take care of a situation, I think we pointed out in the brief, chronologically, that does not make sense. My client allegedly made that statement the weekend prior to Mr. Panduro's death on Tuesday, May 8th. The package that the state and the state on appeal allege is the cause of all this was not allegedly delivered or picked up until the following day on Monday, May 7th. So the evidence shows that my client is asking people to resolve a situation that didn't exist at the time that he made the statement. So we believe the evidence is insufficient to show he had the premeditated and deliberated intent to cause the death of Mr. Panduro, or that he took any actions to do so.
Thank you.
Thank you all for your time.
And the court will now recognize the appellee, Ms. Worthen.
May it please the court, my name is Chris Worthen and I represent the state in this matter. The crux of this case is that this is a drug dealing enterprise in which the members of the drug dealing enterprise turned against each other, and it resulted in the death of Leo Panduro. What I'd like to focus on today is the sufficiency of the evidence. I'd like to address the issue of statutory construction regarding the delivery of methamphetamines, and then finally, if there's time, address co-conspirator statements. What's being left out, and Justice Wood mentioned this, is all of the events that transpired prior to Leo Panduro being murdered. So Zachery Keesee was telling multiple people that Leo Panduro and his partner, Francisco Ocho, Frankie from California, wanted to hurt him or kill him or kidnap him because there was stolen marijuana and he was taking the blame for it. So he told his sister that Frankie and Leo were trying to set him up and that they had stolen the weed and they were trying to frame him for it, and that he was going to be killed that night by Leo Panduro. He told his girlfriend that he had just dodged getting kidnapped and that Frankie had gone too far just a couple of days before the murder takes place. He told another witness that Panduro was threatening to cut off his fingers if he did not give the money that he owed, but he had a plan. He was going to get his boys from Texas to come down and take care of the situation. There's a lot of argument about where these boys were from, but ultimately the witness said they were from Dallas. And sure enough, Andrew Morstein and Christopher Bynum were in fact from Dallas. And Morstein said what the plan was to his girlfriend. There's a disagreement here with the briefing. Keesee believes the statement was made after the murder took place, but it was not. It was made prior to the murder taking place. Morstein tells his girlfriend that a lot of drugs were stolen and we have to go to Arkansas to, quote, kill him. And that's exactly what happened. So on the day of the murder, there are actually 3 people that show up at the hotel room in 2 vehicles, both of which are tied to Keesee. Only 2 people get out of the vehicles. That's Bynum and Morstein, but they're there at Keesee's behest. And we know that drugs were involved. There's suspected drugs in the room that Leo Panduro was renting. He also rented a hotel room down the street that we know contained 1 kilogram of methamphetamines. And so they go in and they shoot him dead and everyone leaves. And lo and behold, 45 minutes later, Keesee's on camera in Sherwood at a shop that his brother-in-law rents with the vehicles. Both vehicles that were at the hotel room were seen. And ultimately, all 3 of them abscond to Mexico, where he makes more incriminating statements. I'd like to address first off briefly but-for causation. But-for causation is not an issue in an accomplice liability case, and it doesn't apply here. A getaway driver would not be let off the hook because the person who went in and robbed the convenience store could have walked away from the scene of the crime rather than got in the getaway car and left by the car. This but-for causation is not applicable. That being said, there was sufficient evidence to convict Keesee on both alternatives, the premeditated deliberate murder and the felony murder, for the reasons that I just said before. And there was certainly addressing the felony delivery. We know that this was...
Counselor, let's talk about the felony murder. First of all, we've got a problem because we don't know what substance really was in that hotel room where the murder took place. True?
Yeah, it was not tested.
Right, so that's a problem. And the drugs that you're referring to weren't even in that establishment. They're across the street and in another hotel room. And then you've got a problem that opposing counsel presented about the word actual in front of the word delivery. And Justice Hood, as she aptly does, has pointed out the grammatical situation that we have with adjective comments. And that's the definition. However, you had legislature going in, putting the word actual in front of delivery in the statute. So does that cause concern when we have I mean, we don't know. There's been drugs in the hotel room where the murder took place. That's one problem. And another problem you got is the factual situation. When you watch that video, you see Bynum and Morstein, when they barrel into that hotel room, they start firing almost immediately. So that to me goes more towards your other theory, premeditation rather than a drug. So can you help me understand those two concerns I have?
Of course, Your Honor. Let me start with the evidence regarding delivery, and then I'll move on and touch on the statutory construction. And Keesee says after the murder takes place, he tells his sister that this was a drug delivery gone wrong. That's his quote to his sister. That's what he says to his sister, that Morstein and Bynum went in there to buy drugs. It was a setup, and Panduro was murdered. That's how he says it. Perhaps the drugs or potential drugs not being tested might be an issue if there were no other evidence that drug dealing was taking place. But that was the business that these gentlemen were in. It was a drug dealing business.
On that particular day, I mean, you can't just say generally it's a business they were in and that money was being delivered. We don't know why money was being delivered. I mean, those are just pieces.
Well, we know that a package was taken that Keesee didn't want taken by Panduro. We know from the journal that Panduro kept that each of the members of this drug dealing conspiracy took packages and dealt in drugs. And we do have suspected drugs in one room and actual drugs in the other. There's nothing in the statute that says all of the elements have to be present in the room at one time for a delivery or an attempted delivery to take place. And that's what we have here. And in Keesee's own words, it was a drug deal. Moving on to the statutory construction. So the legislature, felony murder, it's commit the offense or an attempt to commit that offense. And under that felony murder, where it says that, it lists the offenses that qualify for capital felony murder. And one of them is violations of the Uniform Controlled Substances Act involving actual delivery. That actual delivery is only delineating within the statutes that are written out there, which statutes actually qualify for felony capital murder. So for instance, it would exclude possession of paraphernalia or possession of a contraband, a fake substance, a fake drug substance. And so actual delivery in that is only delineating what crimes constitute felony capital murder. And it does nothing. Actual delivery in that language does nothing to modify the language above in the felony murder statute that says that it's an actual or attempt at the crime. And of course, as Justice Wood pointed out, the actual definition of delivery includes an attempted delivery. And in fact, at trial, the court went over the instructions and actually struck out the constructive delivery part of it and just used the actual or attempted for the jury instruction. And so there's no problem with this. Nothing is superfluous in this. The odd result that you would get was, you could put actual or attempted delivery down below in the felony murder statute, but you would get attempted. You get up above, it would say actual or attempted commission of the crime, and then you would get actual or attempted written again down below, and that doesn't make a lot of sense. So again, it's just delineation between the two. Now, that being said, regardless, the jury found Keesee guilty on both alternatives by special interrogatory. So even if this court were to find that there wasn't sufficient evidence of a delivery or an attempted delivery, or that there was something wrong with the statute with regards to that, Keesee's still guilty of premeditated and deliberate murder. And that's what the jury found. And so this court could affirm regardless of the issue regarding delivery. I see that my time is up. I'd ask that this court affirm Keesee's conviction.
Counsel,
Well, you still have 10 minutes.
Oh, I'm sorry. I looked at the top. I'll keep going. No problem.
Counsel,
Question?
Counsel, I do have a question. I was hoping you weren't going to sit down.
I won't.
My question is, and we can, the sufficiency, you're right, that if we find there was sufficient evidence on one then the other can, falls off. But the appellant has raised quite a few evidentiary issues. And if the appellant is successful on those, then it would go back to the trial court. And I think that's why this court is paying particular attention to both issues. And so I do want you to address, and you mentioned earlier, the co-conspirator statements. And one of the issues and points on appeal that appellant has raised is the statement by Julie Hollister, that she stated that the shooter before the murder testified that they were going to need to go to Arkansas and going to kill him, meaning the victim. And that came in as a hearsay exception, and argued, I believe, as a co-conspirator statement. And that would have to be in furtherance of the conspiracy. And so my question to you is, how is Andrew telling that to his girlfriend in furtherance of the conspiracy?
Sure, of course, I'll be glad to address that. Thank you. This court's black letter law in Dyer, the case that I cite in the brief, is that the identification of a co-conspirator is allowed into evidence. It is the furtherance of the conspiracy. And so I slightly shorthanded the quote that Hollister gave. She didn't just say they were going to go to Arkansas to, quote, kill him. They said, I'm going with Christopher Bynum to Arkansas to kill him. Appellant counsel and I disagree, but read Dyer. Dyer is black letter law that identifying a co-conspirator is in furtherance of the conspiracy and is admissible. Really, and regardless, the court could have allowed the statement in just as a statement of Morstain's future plans. It would have been admissible under that had the court chosen to go that route.
So in your suggesting an 803 3 exception, similar to the statement that they allowed the statement by, I believe, the sister saying the brother-in-law planned to go to the Days Inn, that came in under the hearsay exception of a statement of a plan. The brother-in-law planned to go to the Days Inn. So likewise, this statement could have came in as a plan to go to Arkansas and kill Panduro.
That's absolutely correct. And of course, on evidentiary issues, this court can affirm even if the court came to a different conclusion, or a different reasoning, but for the correct conclusion. And I would point out with all these
I guess you didn't raise that though at trial court or in your brief.
No, not at all. But it doesn't actually prohibit this court from making that holding at all. Regardless, even moving on from that, it's clearly the identification of a co-conspirator. And I would mention that talking about all of these evidentiary issues that have been raised in this 12-point brief, I don't think that there's any one issue that even if this court found a piece of evidence that the court abused its discretion in admitting something that it would rise to the level beyond harmless.
That's interesting, counselor, because that leads me to my next question, and that's about the failure to indicate the journal. Help me understand how will we know whose journal that was, its handwriting, it contained.
So the journal, the authentication of the journal is the facts surrounding the journal and the circumstances in which it was found. And so here's what we know about the journal. It's a detailed accounting of where the packages are going, who's owing money, who's receiving money, and what the expenses are of this drug enterprise. There was testimony from someone else that Leo Panduro's job in this enterprise was to keep track of the money and to make sure that it got back to where it was supposed to go. It was found in Leo Panduro's luggage in a hotel room that Leo Panduro rented, surrounded by items that are in furtherance of a drug conspiracy. A lot of cash, money orders made out in the amounts of $900, deposit slips, a debit card with Francisco Ocho's name on it. And then look at the actual content when it's read in the record of what's in the journal. So every single person that's a member of this drug conspiracy, Zachery Keesee, Andrew Morstein, Christopher Bynum, Francisco Ocho, all of them are mentioned in some way in those journal entries. It's Andro, Spanish for Andrew, as was testified at trial, and also the name that popped up on Panduro's phone when the messages were taken off from Andrew Morstein prior to the murder. Chris is mentioned, Zach is mentioned, everyone is mentioned except Leo Panduro. It's his journal, it's in his stuff. That's good enough. It's all a part of it. It is what it says it is. And even if it's not specifically authored by Leo Panduro, which it is.
You didn't have a handwriting expert or anyone tell us that. I mean, that's conjecture, what you just said.
Well, it's not, I disagree with that. I don't believe that it's conjecture. I believe that it's a reasonable conclusion based on the circumstantial evidence surrounding.
Well, but you said that in a definitive way. You said in a definitive way. And it is, we did not have a handwriting expert, nothing introduced to prove that is his handwriting. He's the one who wrote that journal.
No, but I don't believe that there's anything that says that the journal can't be entered because there was no handwriting expert to say that Leo Panduro did so. We're talking about a conspiracy to deal drugs, a conspiracy that was found by the trial court that a prima facie case had been made. And so because it details the conspiracy that was taking place, found next to a kilogram of methamphetamines, it was certainly admissible. And it was certainly admissible even if it wasn't 100% sure that Panduro was the author of it, although the circumstantial evidence does show that he was the author of it.
Counsel, was the journal admitted to prove the truth of the matters and the facts within it? So in a sense, was it admitted to prove the truth of the matters, that what the statements in it were true? Or was it admitted to show something else?
It's a co-conspirator statement. It was admitted as a co-conspirator statement, and a co-conspirator statement is entered for the truth of the matter asserted. So, the truth of the matter in that it's a journal, and that journal was found and it had names and money amounts in it, right? It's in furtherance of a conspiracy. That's what it shows. It's in furtherance of a conspiracy.
And I think that's what Justice Hudson's getting at, is that if that's the state's position, it's a co-conspirator statement. What have you really shown that was his statement in writing?
It's a co-conspirator.
That's what she asked you.
Sure, and I understand. But it was admitted as a co-conspirator statement. And again, reiterate that the circumstantial evidence shows that Leo Panduro was the author of it. But regardless, even if the journal were admitted in error, which I don't believe it was, it's harmless error based on all the other evidence that Keesee's guilty in this matter. So ultimately,
it seems like it could have been a pretty important piece of information. And you've got this felon murder situation out there, and we don't know what substance was in the hotel room where them killed. You're talking about conspiracy, and so this journal seems to be a pretty critical piece of information. I don't know that harmless error would absolve that.
If you take away the journal, then what would the evidence be that a drug dealing conspiracy took place? There was evidence that Keesee and Morstein engaged in a drug dealing, a drug exchange between each other. There was evidence that Keesee and Panduro did so. There was evidence that Francisco Ocho from California, who presumably is where the money goes to, that Keesee and Francisco Ocho had a relationship, that they had a banking relationship, that they had an LLC together. We know that a package was taken. We know Keesee talks about, and certainly talks about after the crime, that he's got to clean up all of the things that he has out there making money or is in his apartment in Dallas. And so he knows Francisco Ocho. He knows Panduro. Panduro's the person that keeps track of the money on behalf of this drug dealing conspiracy. And we know Morstein and Bynum came down to take care of this. And we know that there was cocaine found in the BMW, in addition to the methamphetamines that was certainly found in the other room. I see that I am actually out of time this time. And so unless
you can respond to the justice's question.
Thank you, Your Honor. I appreciate it. And so at the end of the day, even taking away the journal, there's still ample evidence that this was a drug dealing conspiracy. And there's more evidence than that. There's a mountain of evidence. There's a mountain of testimony in this matter. And the journal is not critical. It's harmless error if the journal is not.
In regards to the journal, if we found it was improperly edited, you're saying we wouldn't need to back for a new trial. Harmless error is what you're saying.
Absolutely, Your Honor. So in conclusion, I'd ask that this court affirm Keese's conviction. Thank you.
Chief, if I could ask a question, please.
Yes.
Two things. First of all, I've got a real problem that the package in the room of Pandora was not tested. I mean, that is an issue that I have. And the only verification of drugs involved are the drugs that were found in the luggage of Pandora, correct?
The luggage, yes, that's correct, Your Honor.
Okay. Address for me the issue that the appellant brought up about authentication of what was found in the luggage, if you would, because that luggage was not found by the officer in the room, but in a closet. Is that correct?
Yes, Your Honor. And so what happened, my understanding is that the luggage is found, the room, it's left in the room, and so it's moved in the closet, and an officer is told that it's in the closet. And then the testimony is that this was the luggage. It's actually a piece of luggage in a backpack that came from Pandora's room. And again, Your Honor, I would point to the facts and circumstances surrounding its finding, even down to, I believe, there was some foot powder in the luggage, and it was suggested there was actually foot powder found on the floor in the motel room where Pandora was killed. We have the debit card that has Francisco Ocho. We have the journal. So all of these things point to that it belonged to Leo Panduro and was in his room. And so the fact that it was moved to a closet rather than being found in his room is inconsequential for the matters of authentication. Is it what it's purported to be? It's Pandora's luggage. They didn't actually object to the luggage. They didn't make an objection to the luggage being entered into evidence. The objection was for the contents of the luggage. But to admit the luggage is to admit that it was in Pandora's room and that the chain of custody was just fine. And so I don't know that matters, Your Honor.
In your opinion, could have it been handled differently as far as testimony as to that luggage being seen with Pandora when he came to the room and or before that luggage was removed? Could that have been handled differently as far as a chain of custody issue? And I understand you're saying the luggage was not objected to, but clearly the contents, there's testimony of what was in the luggage. And so I think that we're arguing about the same thing as far as authentication.
I mean, Your Honor, this, like so many things that take place in any trial, could have potentially been handled differently, but defendants aren't entitled to a perfect trial. And as we all know, prosecutors don't always put on a perfect, flawless case, or the judge put on a flawless case. Regardless, we affirm those cases all of the time because justice was served. And so, sure, it would be nice if the drugs found in Pandora's room had actually been tested. And sure, it would have been nice if there was a little more testimony about the luggage, but it doesn't change the fact that it's Leo Pandora's luggage found in his room. And it doesn't change the fact that Keesee's guilty for this.
Thank you.
Are there any other questions? Okay, thank you, Mr. Worthen.
Thank you.
And the court will permit a rebuttal for the appellant. Mr. Kaiser.
Thank you, Chief Justice. Just starting with the items that the justices just asked about, I'm going to start with the quote journal. We believe the quote journal was not sufficiently authenticated as it didn't show a clear connection to the crime charged. Keesee was not charged with being a drug trafficker. He was charged with killing someone with premeditation and deliberation, or killing someone in the course and furtherance of a particular actual delivery. As Justice Wynn pointed out, the luggage itself was not found in Lionel Panduro's hotel room, as the state alleged today in oral arguments. It was found in a storage closet. As Justice Hudson pointed out, there was no handwriting expert. And I understand that Lionel Panduro may be a Hispanic sounding name, but merely having that name does not mean or prove that the individual speaks or can write in Spanish. There was no proof that Panduro actually spoke or was able to write in Spanish. And in fact, the only proof was that his ID was from the state of Wisconsin. So it's our position that that was not authenticated properly, and that this court should reverse based on that. Moving to the co-conspirator statements as non-hearsay.
Mr. Craig, before you move on, is opposing counsel incorrect when he says that your client did not object to the luggage itself, only to the contents later?
Yes.
Okay. So if they didn't object to the luggage itself, how do you then make the leap that if you're essentially acknowledging by not objecting that the luggage was Mr. Keesee's, kind of help me bridge that gap to then objecting to the contents of the luggage were?
Justice, for the same reasons I've stated, they argued that each of the items contained within the luggage was unauthenticated because the piece of luggage itself was found in a different room, and they couldn't tie it to Mr. Panduro specifically.
All right, talk to me a little bit about the alleged error on the Morstein statement to Hollister. I don't think you covered that in your initial presentation.
Great minds think alike, sir. That's exactly where I was going. So the state points to this Dyer case to say that a statement identifying a conspirator's role is sufficient to fall under this exception. However, this court in Dyer and Leach made clear that a statement identifying a co-conspirator's role to another co-conspirator counts, or to someone they are attempting to pull into the conspiracy. But mere braggadocio to a spouse or partner, as here, this court, the Eighth Circuit, courts have found that does not fall into this exception.
So if we accept your argument that the statement was erroneously admitted, how do we get past whether or not it's a harmless error? If it was an error to admit it, in light of all the other evidence, since this was not just the key piece here, how do we get past the harmlessness?
That's an excellent question, Justice. Without that statement, there's no, I don't believe the connection is enough for sufficient evidence, but there's not even a connection between Keesee's earlier statements regarding purported threats from Panduro and getting his boys to take care of a situation, and then two of his compatriots or associates from Texas actually showing up in Arkansas and killing the individual.
Counsel, can you respond? Can you respond to two things? One is his statement to the girlfriend in the co-conspiracy and the furtherance. This is the girlfriend who basically fled and went to Mexico with him after the murder. So in that sense, could it be furthering sort of the murder and the plan, since that she fled the country with them? And then secondly, what the state brought up in the discussion is that Rachel testified to the brother-in-law, and that the hearsay exception came in for, I'm going to the Days Inn as a hearsay exception. That why wouldn't I'm going to Arkansas come in as a hearsay exception?
Yes, Justice. So first off, is that statement made in the course of the conspiracy? Possibly. Is it made in furtherance? Absolutely not. How Morstein or Bynum bragging to their significant other about their purported role or intent to kill someone, it doesn't do anything to further it, and in fact may actually go against it, and that you've now created another witness who can thwart the conspiracy before it happens. With regard to the 8033 issue, I would point out, as one of the justices point out, this is not something that's been raised by the state or briefed, but I will do my best to address it now. The statement specifically was that I'm going to Arkansas to kill someone for stealing drugs. At the very least, a huge portion of that statement does not fall under intent. The portion about Mr. Panduro or whoever they're going to kill allegedly stealing drugs is not in any way associated with the intent of the speaker. With regard to going to Arkansas, it'd be our position that that is the most that would be admissible under that exception. The intent to go somewhere.
Thank you.
I see that my time is out. If there are
There-
no more
Questions? Okay, thank you, Mr. Kaiser. That concludes the argument in today's case. Justices will reconvene in 15 minutes, and this session of court will be adjourned.